Hello, fellow seekers. I hope everyone is doing well. I'm sure most of you have heard by now that due to Hurricane Milton, the trial for Sarah Boone has been postponed to Monday, October 14th, which is really a smart decision. They were in there this morning trying to select jury members, and the chief judge, I believe they call him or her, made the decision to postpone it until then, which really makes a lot of sense. Number one, the attorneys and people there, might suffer storm damage, and there's no way of telling for sure where the potential jurors are from. And during this time, people are going to be very concerned about their homes, and there could be loss of electricity for long periods of time. So I believe that was a very, very smart move. Makes sense. And it gives the attorneys an extra week to do more motions. But so what I think is the dumbest thing I've ever, I don't know what it is. I am definitely triggered because Sarah's smugness is just incredulous to me. You see that. She rejects a plea deal of 15 years for manslaughter. And there's going to be some new documents where there are things that I had not heard about before that happened that night. So stay tuned, because that is super interesting. And after reading all of those, I can't believe she didn't accept it. But I think that she very much loves to be in control. And I think, Mr. Owens, maybe that's why they get along. I'm sure he strongly urged her to take that deal. Because they were talking about it, and they said she's already served, almost 5 years. It would end up with her getting maybe just like 8 years, maybe 10, I don't know, something like that. But she would be in her 50s. She would still have an opportunity to live a full life. But I don't know. I have a few thoughts, but I think that she loves this. I think she loves this attention because everything is all about Sarah. And I think she wants, like she has for all of these years, and I got to give her props for that. Maybe there's a little bit of smartness in her, but not the kind of smartness I enjoy. But, to just keep this circus going on, and it gets her out. She gets to take field trips. Now she's going to, I noticed, I think they'll show it, but I think she has on regular street clothes today, but it looks awful. It looks like the same color pretty much as her prison garb. And I'm like, oh dear. And I know they okayed dress shoes for her, but I don't know why she might as well just wear her slides with that, because and I think they did agree to her hair too, but of course no makeup due to what they've already said before. But I think she likes it. She's going to make it stretch out as long as she can. And I think she's just determined she's going to get out, just like the day she walked into that interrogation room. Until it got toward the end, she thought she was going to be able to walk out of there with her phone. And I don't know, but people like her, just a smugness of her too. You'll see it when she rejects the offer from the state. And I'm sure they've offered it to her more than once. And if she rejects it like she did, the minimum that she would be serving at this point now, if she's found guilty by the jury, the shortest amount of time would be like 22 and a half years. So I can't even, I have no idea why she didn't take it. Can anyone tell me why? Well, I think I told you a few reasons. I honestly don't think that Sarah has a place to go. I think she's fairly happy in jail, to be honest. And she just loves creating all this drama, and she's probably going to be very, like, depressed once this trial is finished, because, you know, she doesn't really have any family. And Brian, I can't imagine him letting her stay with him. I mean, and poor Lucas. I wouldn't want her near poor Lucas. But that's their business, of course. But I don't think really she has any place to go. I mean, I don't think somebody like Sarah has many friends. I mean, seriously. And when you hear me go over some of these motions, it's going to go over some of the stuff she was talking about when the detectives were interviewing her, and talking about the neighbors that talked about her being intoxicated, and she was saying, well, that person isn't nice, and that person isn't nice, and this, and oh my God, she is, I'm sorry, she is just a horrible, horrible individual. And I know I've gotten like perhaps too emotionally connected with this, but it's just because I feel so horrible for George's family. That's who I always go back to, that they've had to wait. Well, she has created this circus. Because like I said, I'm not a psychologist, psychiatrist, lawyer, paralegal, but I do think she is a narcissist. And I wish you could go, I wish that there was a crime that she could spend life in prison with no parole, just for being an insufferable, narcissistic bitch. They should make it a law. She could be the first that they could apply it to. But I really can't. I'm just so annoyed. So I'm going to go ahead and play this. This is not very long. It's just showing her very smugly rejecting the plea deal of 15 years for manslaughter, which she would have gotten out sooner. But, you know, she's just, I just can't. I can't with her. But then after that, you're going to hear the people on court TV talk about what they think about it. They're just like, what? Like all of us are. But look at her. Okay. Enough. Here we go.
Do you understand that if we were to proceed to trial in this matter, and if you were found guilty, the lowest permissible sentence that the court could levy in this case would be 22.5 years in the Department of Corrections? Do you understand that? Do you understand the state's offer to resolve this case? Okay.
He's probably saying, Sarah, take it.
15 years to a lesser included charge of manslaughter, with the understanding that she would serve 85% of that sentence.
That's up to the department and her behavior, but that is my understanding.
Ma'am,
Look at her face.
Understanding the state's offer, do you wish to accept or reject the state's offer to resolve this case?
Oh,
Just look at his face.
Rejected that offer. That's 8. You heard there. It was 15, but she would serve 8, and she's already done, I believe, 4 in jail. Go ripping through these 9 attorneys. She's
That's
4
incredible.
years away from getting out if she accepted that deal, and she said no. Oh, Deputy Public Defender in Los Angeles County, Philip Dubay, is here. He's been sitting next to clients for decades, listening to their offers and rejections and this. Where does this stand? I mean, this to me seems like a no-brainer. Take it, take it, take it.
Suitcase Sarah is a classic example of why we have a job. Okay,
Oh my God.
She's the type of client where you need to double team her, meaning you bring in at least 2 lawyers from your firm or your office to sit her down and tell her to knock off the cock and bull and take the deal. Because when she gets out, she'll be 56. She'll have a whole life ahead of her. You know, she's already been in for 56 months. I believe she got arrested on this in February of 2020. So she'll still be a relatively young woman. Worse yet, when you do the legal analysis, I think the best she can hope for from the jury is a manslaughter. They define it as follows. All they have to do is prove that she committed an act, not in self-defense, that caused death. That's it. All they have to do is hit the play button and show the jury that video of him struggling for breath in that
Exactly.
suitcase, and they've basically proven the, of manslaughter beyond a reasonable doubt. So what does that get her? The 15 years that they're offering now. Homegirl needs to take the deal and shut up and go do her time.
Yeah,
Because
seriously.
Because the chances of a second, while obviously the state is a little bit worried about their case because it is complex, that video, she's not only listening to him, she's taunting him, and there's only 6 jurors that are going to be deliberating in the state of Florida. It's not a 12-person jury. You could just feel this thing going south very quickly.
Oh God, look at that.
Like
Look at
they
that.
articulated, their defense is going to be battered spouse syndrome.
Maybe.
Yeah, the only way out of this is to prove some form of self-defense. Because again, they have to prove she committed an act that caused death that was not excusable, meaning it was not in self-defense. And if they think that a battered woman syndrome expert is going to save the day, it's very risky. I would rather take my 15 with all the credit I've got in and be out at age 56 rather than risk life in prison. But she's willing to roll the dice. It's really unfortunate, and this is, again, a classic example of why a few attorneys need to sit her down and explain the risk. And then you can note your file, say she's been advised, and if she goes down on it, she has nobody to blame but herself.
And now it makes sense that she's gone through all these attorneys. We had sort of speculated that the state maybe was offering and she was rejecting, and this, and I think that the state was very eager to get this out on the record and into the public forum.
I'm just giving a visual to you all right now of, see, is that her outfit. I mean, I know you can't see a lot, but it doesn't look very attractive. And did her hair get done today? Or are they waiting for that until I don't know. But see, that doesn't, no, that doesn't, let me see. Let's see if we can see a little bit more. Yeah, and that's that. She loves it. She has got all these people surrounding her. Ugh. I guess that's about all you can see, though, of that. But I just thought that was worth sharing. You all, I know you didn't get to see a lot of it, but at least it gave you an idea. That didn't look like anything special. But hey, I'm just blown away. But we're talking about Sarah, Samsonite Sarah, Suitcase Sarah, Loony Boone. Oh my gosh. Can you imagine what another kick in the gut this is for George's family? I'm just like, I just pray that very, very soon they get this resolved and finally justice. My gosh. Okay. Now we're going to jump over to the documents where there's some very interesting things. So this is a motion from the defense. It's defendant's motion in limina. I think I said it right. In limina. Close enough. Okay. I guess the one positive thing, there is no positive thing about Milton, Hurricane Milton. But with presumably trial starting a week from today, the 14th, the jury selection thing and all that, it will give the week, this whole week, granted they have electricity and all that kind of stuff, to do all these motions back and forth. Oh, goodness, help us all. But anyhow, this is what the defense has to say. They want some things taken from the video now that they know it will be played, the 2-hour interrogation. So it says, the defendant by and through the undersigned counsel and under sections 90.402, 90.403, all of those numbers, sorry, put my hand there, Florida statutes request this honorable court to exclude certain evidence at the trial of this cause, specifically redacting portions of the 2-hour video interrogation at the Orange County Sheriff's Office, and as grounds alleges as follows. Number 1, defendant Sarah Boone is charged by way of information with a single count of second-degree M. The offense allegedly occurred on February 23rd, 2020, not 2024, in Orange County, Florida. Excuse me. There's stuff blowing around outside from the storm, so excuse me, or the coming storm. Number 2, during the homicide investigation, the defendant was asked to come to the Orange County Sheriff's Office. The defendant arrived on February 25th, again, 2020, and was escorted into an interrogation room. A custodial interrogation of the defendant then ensued. Number 3, the approximate 2-hour interrogation was recorded by audio and video. During the interrogation, the 2 homicide detectives questioned the defendant at length concerning the facts and circumstances surrounding George Torres's deed. 4, at such time, statements were made by the defendant and the 2 detectives. Some of the statements made by the parties should be excluded and redacted from the video mentioned above. Number 5, from the transcript of the interrogation video titled Transcript of Taped Interview of Sarah Boone conducted by Detective Chelsea Copsel, Case 20-17904. Okay, so the first section of evidence to be excluded. Number 6. The following dialogue from pages 69 through 71, beginning on line 6 of page 69. Detective Scott Lowen. Hold on. You had 2 different neighbors that live directly next to you. You asked to use the restroom, and they told you no and turned you away. You had to go. Sarah Boone. Oh. Detective Scott Lowen. Across the way to somebody else. Sarah Boone. Oh, no. Okay. Kim and Eli. Eli. Or Kim is not a nice person. I love this. I remember this interrogation. She always, if somebody does not find her favorable, she's going to say some shit about them. Let me just get real here. Detective Scott Lowen. Okay. Sarah Boone. She's just automatically not nice. Even after me and Lucas went over there and introduced ourselves, she's just not a nice person. Detective Scott Lowen. Then why would you think she would let you use her restroom? This is really almost comical if it wasn't so horrific what happened to George. But this part is funny. Sarah Boone. Because Eli was in there. Eli comes over and talks to us sometimes, which I think pisses Kim off. You know what? She is so middle school. Oh, my God. Detective Scott Lowen. Okay. Sarah Boone. Because he comes over and talks to us. The 2 of them, they're like super standoffish all the time. And the neighbors down the street down the way, their toilet was broken. They had stuff in the bathroom. So then Detective Scott Lowen, bathrooms. Sarah Boone, like, go over there and try over there. Detective Scott Lowen, there's 2 bathrooms, so both their bathrooms. Sarah Boone, I wouldn't let anybody go upstairs and use my personal bathroom. Sarah Boone, that's what the downstairs one is for. Detective Scott Lowen, or somebody you knew. Sarah Boone, they're in the process of doing all this stuff in the kitchen. Detective Scott Lowen, okay. Sarah Boone, and there's stuff in the bathroom and there's stuff in the bathroom and the toilet doesn't work. Just move across the way, no problem. Sarah Boone, and of course they let me in. Them and them, they're together. They're apart, they're families. That's what you really want to know, and I hope it doesn't get them in trouble. But he's over here illegally, so he's trying to work on getting his green card. She's such a snitch. Detective Scott Lowen, what does that got to do with you using the restroom? Sarah Boone, they didn't want to be involved. Detective Chelsea Copsel, what's the address? Detective Scott Lowen, no. I was asking last night because, we had several different people. Sarah Boone, assuming. Detective Scott Lowen, stay in the neighborhood, come up. Sarah Boone, Eli and him. Detective Scott Lowen. Do I have this one in the right place? Yeah, I guess I do. Stay in the neighborhood, come up. Sarah Boone, Eli and him. Let me make sure I have this up all the way. There we go. Detective Scott Lowen. Saying that she was drunk on a regular basis. Speaking of Sarah. Sarah Boone. Eli and Kim. Okay. Did you ask Benny next door? Sarah Boone. Those are the ones next door that she asked to use the restroom and they said no. God. Detective Scott Lowen. No, she said no. Detective Chelsea Copsel. Okay. Sarah Boone. Like I said, she's not a nice person. Gosh. You can see why they want to redact that. That sounds ridiculous, but it certainly sounds like how Sarah doesn't like anybody. Everybody's awful and she's going to tell on the people. Oh, my God. Okay. Here we go. Number 7. The exclusion of the said evidence is required due to lack of relevance under Section 90.402 Florida statutes. In addition, the evidence is improper character evidence under Section 90.404 Florida statutes. Okay, the second section of evidence to be excluded. Number 8, page 53, line 11, Detective CK. Well, he's D as a result of your actions. Detective CK. He's D as a result of your actions. Sarah Boone. I understand that. Trying to read it how she would read it in her soft voice. I can't do her very well, but nobody can. Well, I'm sure y'all can. And then they're saying 11, page 55, line 24, and this is Detective Lowen. I have one last question. You realize you're the person that K'd him, right? And then Sarah Boone, I thought about that. Yeah, okay. And Detective Lowen, well, intention or not, George is D. You act like when you say unintentionally, that absolves you from everything. Right? Have to agree with him on that one. It says, 14. The above evidence is improper opinion testimony by a law enforcement officer. Law enforcement cannot express opinions on the law or the ultimate issue of fact for the jury. 15. In addition, and statements assume the truth of contested facts and encourage the jury to find the defendant guilty is charged because a law enforcement officer said so. If the opinion evidence is admitted, the jury may assume the validity of the law enforcement officer's opinion because it was allowed in evidence and rely on the opinion in finding the defendant guilty. The issue of causation is exclusively the jury's job. This opinion evidence invades the province of the jury's fact-finding mission. 16. The exclusion of any or all of the evidence described above is required as the value of such evidence is substantially outweighed by the danger of unfair prejudice, confusion of the issues, misleading the jury, and would serve only to inflame the jury. And then it's doing he did some case sightings. Good for you, Mr. Owens. Okay, so it says, wherefore the defendant requests the court to enter an order excluding the above statements from the videotaped interrogation in this matter. So this is the state's response to defendant's motion in limine. Limina. Good grief. Sorry about that. Regarding defendant's February 25th, 2020 statement. Comes now the state of Florida by and through the undersigned assistant state attorney and alleges and states as follows. Number 1, the state does not object to the defendant's request regarding pages 69 through 71. And that is the one about Sarah and Detective Scott. First name Scott. We're talking about the bathrooms and how this person wasn't a nice person and blah, 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 and they didn't want him to use the bathroom. So they agree with that, but they disagree. It says, number 2, the state does object to the defendant's request regarding pages 53, 55, 56, and 92. The statements are designed to elicit responses from the defendant, and they did. They are not statements regarding the law or an ultimate issue of fact for the jury. At issue is whether the D was an accident, as she continuously insists in the case, even as recently as October 1st, 2024. Not whether she caused his D. Number 3, the defendant can request the court to read Florida Criminal Jury Instruction 2.8, recorded interview, effect of law enforcement statements on the defendant. It reads as follows. You are about to watch a recorded interview that contains opinions and statements by Detectives Copsell and Lowen to Sarah Boone. These opinions and statements are portions only to explain the reactions and responses they elicit. You are not to consider these opinions and statements by the police officer as true, but only to establish the context of Sarah Boone's reactions and responses. This is where things get really interesting. And we're going to, at least I'm going to hear some things I've never heard before about that horrible night. So this is from the state. State's motion in limina to exclude battered spouse syndrome evidence or exclude mention of battered spouse syndrome evidence until the defendant testifies to a justifiable use of deadly force. comes now the state of Florida by and through the undersigned Assistant State Attorney and states and alleges as follows. Introductions. Number 1, the defendant has filed a notice and an amended note of her intent to rely on battered spouse syndrome evidence in this case. Number 2, battered spouse syndrome is not actually a defense to a crime. The introduction of battered spouse syndrome evidence to support a self-defense theory is not for the purpose of justifying a defendant's misperception of reality or to explain why an unreasonable belief was nonetheless justifiable due to her condition. Rather, the Florida Supreme Court has sanctioned the use of battered spouse syndrome to show why the defendant's actions were reasonable, to show in spite of a reasonable perception of danger from the battering spouse, the battered defendant would remain in the home with her batterer, where she may resort to the exertion of force against him to prevent imminent or great bodily harm. And there's all the case laws there. Facts. Number 1, the defendant has presented several accounts of what happened on February 23rd, 2020. She made a 911 call at approximately 1 p.m. on February 24th, 2020. She spoke to a patrol deputy on body-worn camera shortly thereafter, provided a statement to detectives a few hours later on February 24th, 2020, and provided a second statement to detectives on February 25th, 2020. Number 4, the defendant retained Dr. Julie Harper as one of her battered spouse syndrome experts in 2020. Over the course of the next several years, Dr. Harper interviewed the defendant about the events of February 23, 2020, multiple times. Exhibit A at the hearing on this motion will be Dr. Harper's deposition, which was taken on October 1st, 2024. The state would direct the court to pages, and it lists all of those different pages, of Dr. Harper's deposition for the defendant's statements about February 23rd, 2020. So now they're going to talk about the state's expert. Okay, number 5, the state retained Dr. Tanya Werner as its battered spouse syndrome expert. Dr. Werner evaluated the defendant on October 2nd, 2024, and Dr. Werner was deposed on October 4th, 2024. Exhibit B at the hearing on this motion will be Dr. Werner's deposition. The state would direct the court to pages 75 to 79 of Dr. Werner's deposition for the defendant's statements about February 23rd, 2020. Number 6, the state is not asking the court to make any credibility determinations about the defendant's statements to the doctors. That would be for the jury to do, in the full context of a cross-examination with the defendant's statements to law enforcement. Number 7, what the state is asserting is that as a matter of law, what the defendant told the doctors does not entitle her to a self-defense instruction, nor does it entitle her to introduce evidence of prior instances of violence, reputation, evidence of the decedent's violence, moving it up, or battered spouse syndrome evidence to help the jury understand why what she did was objectively reasonable. Number 8, the defendant told the doctors that because of past violence between her and the decedent, she had a generalized fear every day that the decedent would cause her serious bodily harm or K her. Number 9. However, on this particular day, the decedent did not take an overt action, even in the slightest, that made her believe he would cause her serious bodily harm or D. 10. According to the defendant, when she and the decedent woke up, the decedent wanted to drink alcohol. She did not, so in order to distract the decedent, she suggested they instead clean the defendant's townhome, which they did. Number 11. At the conclusion of the cleaning, the decedent still wished to consume alcohol. The two of them began consuming alcohol. The defendant did not want to consume alcohol, but she did so to placate the decedent, George. Sure she did. Do y'all believe that? I don't. Number 12. The alcohol that they consumed was a Chardonnay bottled by Woodbridge. Number 13. In order to prevent the decedent from becoming sad or upset, she kept him diverted by smoking cigarettes with him, drinking, enjoying each other's company, perhaps using the dartboard on her porch, and doing arts and crafts and puzzles. 14. Although it apparently would upset the decedent, the defendant suggested he call his daughter, who did not like talking to him when he was drinking, or that he call his brother to tell his brother that the decedent had dragged the defendant down the stairs the night before. Oh my gosh, this is nuts. Again, all about Sarah. Number 15. Having done these playful activities for numerous hours, there came a point where the defendant and decedent were sitting on her couch in the downstairs living room, and the decedent tagged her and said, "You're it." From past games of hide and seek, the defendant understood this to mean that he wanted to play hide and seek. She begrudgingly engaged in this game, as with everything else, to placate the decedent. Number 16. She ran up to the shower. After becoming cold and perhaps some misunderstanding about the rules of hide and seek, she left the shower upstairs and returned downstairs to find the decedent placing himself in a suitcase to hide. Now, that's the first time I've heard that. Maybe not you all, but that's the first time I heard that. At the time of his demise, the decedent was only 103 pounds. Oh my gosh, I remember one of y'all telling me that, and because when I looked up, of course this was, a while back, but I looked up him and Sarah and their height and weight, and he was like 5'4" at the time. Well, this was back prior to this whole terrible thing. He was 5'4" and 140, and she was 5'3" and 130. If he was just 103 pounds, was he terribly ill or something? That is like tiny. And wow. And had a blood alcohol level of 0.138. Number 17. The defendant saw him doing this and decided to zip the suitcase shut while the decedent was inside it. Yeah, this is a whole new thing I'm hearing here. They were both laughing, and there was still no animus between them on this day. The defendant states she did not zip it completely shut. The decedent was able to poke a couple of fingertips through the gap left by the zipper. As we all know now, I don't think there was any doggone gap. Number 18. And then the decedent said he could not breathe. The decedent obviously got mad about not being able to breathe. Now, I don't, at any time, at least during the recording, he sounded like he was like, "Please get me out," but he did not sound angry to me. But maybe there was a part, we didn't see. Anyhow, the decedent obviously got mad about not being able to breathe. Yeah, I'd be pretty mad too. The decedent's getting mad made the defendant get mad. This reminded her of the past violence the decedent committed against her, causing her to be unable to breathe at those times. This made her angry. The defendant shook the suitcase. She lost control and the suitcase flipped. She hit the decedent's fingertips with a wooden baseball bat that was in the room. Aha! I knew the baseball bat would be coming into this. But his fingertips, that would be his fingertips that were allegedly sticking out the suitcase, which I don't think they ever were. And I don't remember from the autopsy report anybody reporting anything about any injured fingertips. 19. Now, after having committed the independent forcible felonies of aggravated assault, aggravated battery, and the non-favorable felony of false imprisonment, the defendant believed the decedent would kill her. 20. Despite believing the decedent George, would kill her, the defendant flipped the suitcase over so it was right side up, and she believed the decedent would be able to let himself out. Number 21. The defendant's specific intent for the decedent to feel like what it was like for her to choke and not be able to breathe. She intended for him to feel this for 2 minutes. I don't think it was just that long. And believed he would let himself out. And when that happened, if she deed, she deed. Number 22. She did not intend to kill him and did not believe that leaving the decedent in the predicament she placed him in would kill him. His deed was an accident. Yep, I don't know. I wonder if the judge will go along with the state. These are some new things, though. I mean, she has so many different sides to her stories. I don't believe any of them. 23. Battered spouse syndrome evidence is inadmissible if the defense is an accident rather than self-defense. The defendant's testimony is that she intentionally zipped the suitcase out of levity and while kidding around with the decedent during a friendly game of hide and seek. Then, when the decedent informed her that he could not breathe, she intentionally decided out of anger to make him feel like he's trapped in there for a couple of minutes while she beat and shook the suitcase and hit his hand with a baseball bat. This is aggravated assault, aggravated battery, and false imprisonment. She stated that she flipped the suitcase right side up, saw that the decedent could get 2 fingertips through an opening, and she went upstairs to bed believing he would be able to get out in a couple of minutes. She had no intention to kill him, so intention to leave him trapped inside of the suitcase. No intention to leave him trapped inside of the suitcase, and she did not even comprehend that he could die from this. Let me pull this up a little bit more. Oops, here we go. The defendant is thus still saying that the decedent's D was an accident, and she is not entitled to an instruction on self-defense or to supplant a self-defense case with repetition evidence, specific instances of past violence, or battered spouse syndrome evidence. 24. The defendant's statement that she perpetually lived in a state of fear of the decedent is not sufficient to allow for a self-defense instruction, and all the ancillary evidence of reputation, testimony, specific acts of past violence, or battered spouse syndrome testimony. Oops, let me get it up here. However, before a defendant may introduce evidence of the victim's character, he must first show that there was an overt act by the victim at or about the time of the incident and reasonably indicated a need for self-defense. Let's see, okay. Victim hit defendant with a 2-inch wide, 4-foot long stick in the hand, causing only minor injuries, did not justify defendant's use of deadly force. Comparing the facts of those cases, it is clear there was not even the slightest overt act by the decedent in this case. 25. Prior to the defendant committing aggravated assault, aggravated battery, and false imprisonment, there was no imminent threat from the decedent. You can't just attack somebody as they walk into their front door and their throat with a knife because 2 days prior they sent you a threatening text message. Number 26. If this evidence is improperly submitted, it would be a departure from the essential requirements of the law, which would result in irreparable harm that cannot be corrected by a post-judgment appeal. The state acknowledges that the defendant is entitled to change her story yet again. So if this court does not exclude the evidence now, the defendant should be barred from mentioning battered spouse syndrome evidence until the defendant testifies to something that is a justifiable use of deadly force. BSS evidence properly excluded until defendant testifies, when that's the only source of information for the defense. Not improper to exclude expert testimony until the facts are in evidence. BSS not available if the defense is accident rather than self-defense. Oh boy. So there you go. So he's certifying that he submitted something to James Owens and the whole other group of Sarah Boones. Wow. I mean, more than ever, I still, especially now after reading this, I cannot believe that Sarah did not take the state's proposition to agree to manslaughter for 15 years. That just, I'm telling you, it's like what I said before. I really think that, number one, she likes this drama. She loves being in the courtroom. I'm sure it's a lot more exciting than going to, than, staying back in her cell or whatever they do. But, she's still just treating it like the prom, which there was another amendment or not a motion or whatever. The judge said that she was permitted to wear dress shoes. But that thing that she had on today, I'm telling you, didn't that just look more like her? I don't think there was time for her to be measured and have somebody make something. That looked, unsightly. My gosh. But I'm just amazed that she did not take that deal. Her arrogance and her smugness just make me want to hurl. But that's my opinion. But I thought I would share this while I could, and I'm not going to say when it's going to be up, because every time I say it, I jinx myself, and it doesn't end up to be when it is. But I will try to get it up as soon as possible. And from here on, I don't know, like with Milton coming, even though we are off the coast and more inland, there's still a very good chance we'll have strong winds and no power. That's just how it goes. And I just pray for everyone, especially the ones who have already been destroyed by the prior storm. I mean, that's horrific. I've been so blessed, and, I just am. And we just have to take one day at a time. But if any of y'all are near the path, if they tell you to evacuate, please, for the love of God, evacuate, because people don't take it seriously. My son is even going to come down to my house, and he's a very stubborn Floridian, but even he's smart enough to know if they say you should go, you should go. I'm not saying they said, but just based on where he lives and all that, he'll be coming this way. And so I just hope that everyone stays safe. My thoughts and prayers are with you all. If you're in the line of the storm, if you've already had damage and you're bracing yourselves for more, I just hope this gets through quickly and everyone will be okay. It's I mean, I'll be okay. We'll be okay here. I mean, of course, there's always a little bit of anxiety, but at this point, if you're prepared, there's nothing else you can do but, as they say here, hunker down and everyone will get through it. Well, in the comments, let me know what you think about, number one, Sarah refusing that very generous offer that the state presented to her. I'm sure that has already been offered to her multiple times, but that little smug self of hers, oh yeah, my theories about her wanting to, make the trial last because she loves being in power. Another thought I had, and this is just very off the wall, it may not be, Sarah, really, if she gets out of jail, she doesn't really have anywhere to go. I'm sure that Brian will not let her live with him. She had said, I remember in one of the initial interrogations when they came on maybe it was with Kayla Rodriguez, she was talking about her family, and she said, one of the detectives, she said that she didn't have any grandparents, her parents had passed away. I think, as I understand, she has one brother that's in the service and another brother that I think is currently incarcerated. So she really doesn't have anyone, unless whomever the person is she's making those goo eyes at is someone that she can live with, unless maybe they're in jail or something, whatever. I'm not sure. But I don't know that she really has anywhere else to go. I'm being serious, honest. It seems like she's been relatively happy, and, having, using all this time to write all these letters and all that has probably kept her excited. I imagine after this trial, when the trial ends, she's going to, experience a severe letdown. Of course, I'm not a psychologist or psychiatrist. I'm just saying that all this hype, the attention, even though she says she hates the media and everyone, reporting on her or writing about her or whatever, I don't think she's fooling any of us. She is eating it up. And once that's done, after a while, things will die down. And I don't know. I think she might be just happy to, stay in jail. But my gosh, to be able to get out and still have so many years in front of you, hopefully, that doesn't even make sense. But hey, that's Sarah for you. All right, guys, I'm going to sign off for now. I may have forgotten something, but I wanted to at least share these things with you. And I hope you all are doing well. And I have been trying to keep caught up with the comments. I'm doing pretty well. I was in the middle of, I think, finishing reading the next, the video before last. But as always, I enjoy your comments. I love your feedback on Sarah and George, and so many times y'all will share things with me that I didn't know, so I appreciate that. And I appreciate you subscribing and commenting like I just said. And if you haven't subscribed already, please do if you like it here. And if not, that's okay too. Okay, so I love you all. Be kind to someone. Be kind to you. And I'll see you the next time.